Finally, I got you in studio, Yanka.
Yeah.
Talk to me about this court case. What does Mrs. Mkhwebane want the Constitutional Court to do for her here?
Well, she applied for an application for leave to appeal in the High Court against this personal cost ruling, which will see her pay up to about 900,000 rand of the costs of the application out of her own pocket. So she went to the Constitutional Court asking for direct access or for application for leave to appeal this ruling, because what she's saying is that it was inappropriate for the High Court to order her to pay out of her pocket, saying that this then actually goes against her independence, because if we have this possibility of the public protector facing a personal costs order, then she will never in the future should be scared to act without fear or favor when it comes to remedial action.
The so-called chilling effect argument.
Basically, she's saying that a gun-shy public protector will not be able to do her work as she is supposed to, according to the Constitution.
But give us context. Why did the Constitutional Court order that she should pay the costs personally for this particular?
Well, this is the High Court that ordered that.
The High Court, that is.
Yes. Well, they're saying that according to this judgment by the High Court, they said that she didn't understand her constitutional duties. She acted, or they questioned some of the actions. For example, she didn't disclose some of the meetings that she had before the release of the report. One of these that was crucial that came up in the Constitutional Court today was one that she had with the presidency, and she apparently does not disclose this meeting or the context of this meeting to the court. And apparently what the Reserve Bank is saying is they actually discussed her remedial action, which according to the bank then a couple of days later was phrased in the report as we know what the remedial action was around the mandate of the Reserve Bank being questioned, as well as the SIU being ordered to reopen that investigation into that apartheid era bailout. So they're saying basically she didn't understand, and she conducted a partisan investigation. She wasn't fair in her investigation, and that's why they believe that she should be held personally accountable, because that's how you vindicate the Constitution.
So there's a lot that's at stake here, Yanka. I mean, if a judgment that damning stands, it potentially has serious implications for her continued tenure as public protector. This perhaps explains why she's likely to fight tooth and nail.
And it gets even worse, as I can explain that the Reserve Bank came in with a cross appeal. Now, this gets quite complicated, but if I can just explain it quickly. She's applying to the court for direct access to the Constitutional Court to appeal this order, ordering her to pay the costs. And what the Reserve Bank is saying is they actually also have a problem with the initial ruling from the High Court, because they wanted a declaratory order from the court saying that she abused her office. Now, they're saying that if she goes ahead with this appeal against the costs order, they will also go ahead asking the Constitutional Court to declare that she abused her office. But it's important because they're saying that they're only persisting with this application if she goes ahead and she gets direct access to the Constitutional Court. So she's basically taking a big risk of pushing ahead with this appeal against the costs order, because if she's granted either leave to appeal or direct access, then the Reserve Bank is saying they will pursue or they will persist with the application to have her or have a declaratory order saying she abused her office. Obviously, that has a much larger and more serious consequences for her future in the office of the public protector.
So it's a bit of a standoff. I mean, you pull the trigger, we pull the trigger. If you want to appeal that order, we are going to then have our own application that says you abused your office.
Well, that's what I actually asked a representative from the Public Protector's Office, saying why is it so important that they go ahead with this if she runs the risk of a declaratory order saying that she abused the office. But what they are saying is that it's going to set a dangerous precedent, as we said earlier, that she will not be able to act without fear or favor if there's always this looming possibility of a personal costs order. So both ways you can almost understand, but it's definitely a risky application, and we'll have to keep a close eye, because whatever the Constitutional Courts decide, it will have dire consequences going forward.
Absolutely. Yanka Tolmay, thank you so much for coming through. It looks like we are in for some intriguing developments in the coming weeks and months at the Constitutional Court in as far as that is concerned.